Good afternoon, everybody, and you're all very welcome to this afternoon's session, Brexit and Beyond, a focus on the current Brexit negotiations, the implications of the likely results or outcomes of these protracted discussions, and obviously particular consideration for the challenges around overseas data transfers. Hugh Jones is my name. I'm a founder and director with Cytorus, and we're delighted to welcome you to this afternoon's session, the latest in a series of webinars we have been doing. The recordings of those webinars are available on our website at www.cytorus.com, and you're very welcome to get in touch with the company if you wish to access previous recordings. I should mention as well that today's session is being recorded for those of you who are of a privacy bent. I know that will appeal to you. In true form, in reference to Article 6, we are not seeking your consent, but would like to make you aware of the fact. Calls and questions will be collated during the course of the presentation, and I will leave time at the end to address as many of those questions as reasonably possible. So I welcome your comments, your thoughts, and your questions, and we'll make every effort to get to them at the end of the session. Without further ado, we'll kick off. So the current state of play in terms of the negotiations, and obviously since the original Brexit decision was taken a couple of years ago now, there have been a number of stages, a number of pushed deadlines, a number of missed deadlines, and why change a good thing? Those deadlines continue to be pushed and missed and disappointing. Officially, in the last 12 months, let's say, the Brexit decision effectively became official on the 31st of January 2020. And that decision, or that deadline, initiated a transition period of 11 months, which will run to midnight on December the 31st of this year. The Brexit negotiations are ongoing, and many of you are aware of the occasional visits either of the UK negotiating team to Brussels or the European negotiating team to London. Process is ongoing with much discussion and much publicity around the various topics. The most recent one being, or seeming to focus and coming to a halt around fisheries and fishery jurisdictions. But the show goes on and the clock winds down towards December 31st. As we currently know, and as we currently understand the state of play, there are effectively 4 options available with varying degrees of likelihood. The first, and extremely unlikely, would be an extension, a further extension to the transition period beyond the 1st of January. I don't think there's any appetite on any side of the bargaining table for that scenario. Obviously, the negotiations could succeed, in which case a formal trade agreement would be agreed between the parties, allowing not only for protection of various commercial activities, but purely from a GDPR point of view, allowing for the smooth and friction-free process flow of data between European and UK jurisdictions. Even if a full trade agreement is not negotiated, there is a possibility that the value and importance of the free flow of personal information will merit a separate or offline trade deal simply to allow for the friction-free movement of data. So even in the absence of a full deal, we may nonetheless, by year end, have a data-related agreement in place between the parties. And obviously the nuclear option, and certainly one that nobody wants, and that would be that we would find ourselves at midnight on the 31st of December with a no-deal scenario, no formal trade agreement between the UK and the remaining 31 member states of the European Economic Area. A number of deadlines have passed. Most recently, November 19th was a summit in Europe that had hoped to present the terms and at the very least the outline of a trade agreement. That was made aspirationally back in the summer and came and went without any documentation or without any outline being put before the European Commission. There is obviously and remains hope for extraordinary summits to take place either earlier or later in December. And it's all every likelihood that this will go right down to the wire. Of the four scenarios I've outlined, the no deal scenario appears ever more likely. And unfortunate as that may be from some perspectives, naturally that is a legitimate and reasonable consequence of the various negotiating parts to the discussions. The starting position for us today will be a no deal Brexit on the basis that it's a worst case scenario from a friction-free movement of data. But obviously any kind of an arrangement, any one of the other three scenarios will be less than that and certainly will be less onerous and less arduous from a data protection point of view. So bear with us. We're going to go with the worst case scenario and set out the expectations on that basis. Naturally, I don't want to give any impression that this is all about the GDPR or all about the movement of data. It is not. We all know from discussions and from media that the Brexit decision is multifaceted and has implications for all sorts of other commercial, social, cultural, and medical activities. Financial services, logistics, transport, the movement of goods and services, social welfare entitlements, the right to work and visa status, farming and the movement of not only animals, but also fast-moving consumer goods, the conduct of clinical trials in the medical or pharmaceutical space, cross-border exchanges between various enforcement institutions, and then naturally the investigations and data sharing between policing authorities and national security organizations. So again, the smooth flow of personal data rests as kind of cement between all of these various institutions and all of these various transactions, but is only one aspect of the fallout and of the implications of the Brexit decision, but certainly one that we will focus on today, given our specialism within the space. At a very high level, in the event of a no-deal Brexit, for the UK to leave the European Union without a formal trade agreement in place, the following implications will take place. Firstly, obviously, and the most straightforward, the UK and Northern Ireland will leave the European Union. And in doing so, will lose the protections of EU membership and be designated a third country. That is, a country outside of European Economic Area membership, but also without an adequacy designation that would give some level of interaction and some level of assurance in terms of the safeguarding and the security of personal data. We'll talk about that a little bit later. Obviously, the UK government has committed to adhering to what has been referred to now as the UK GDPR, a slightly modified version of the General Data Protection Regulation that takes account of certain modifications to UK institutions, removal of commitment to the EC, the European Data Protection Board, and to the various one-stop shop mechanisms or consistency mechanisms, but nonetheless a broad commitment to adhere to the UK GDPR and to the UK Data Protection Act. The formal decision back in January 2020 triggered the Keeling schedule, which was adopted to modify references in a raft of UK legislation to modify references to UK institutions and European institutions. And that process, the drafting of those items of legislation, is ongoing as we speak. In the context of the GDPR, from the 1st of January, in the context of a no-deal Brexit, the UK can no longer be nominated by a company as its main establishment. So organizations across the European Union who may have representation in multiple European member states and who may have availed of the opportunity to nominate the UK as their main establishment must now modify that decision, because from January 1st, the UK can no longer hold that title. Separately, the Information Commissioner's Office, while it will remain the de facto supervisory authority for the UK, can no longer be the lead authority for non-UK companies, nor can it sponsor an organization's application to have binding corporate rules evaluated. Again, relatively few organizations have opted for the option of binding corporate rules, but where the ICO was leading, and at last count, to my knowledge, 18 different companies around the world had engaged with the ICO to be their sponsor for the binding corporate rules process. If the BCRs are not signed off before the 31st of December, then those organizations will need to find an alternative EU member state to sponsor their application. In the event of a no-deal Brexit, and where organizations are continuing to trade, UK organizations are continuing to trade with member states of the European Union, UK firms will need to nominate an EU representative, otherwise known as the nominated representative, for obvious reasons. We'll look at this a little bit later on. In reverse, non-EU firms continuing to trade in the UK must also nominate a UK representative. And this will also apply to European Union companies. So the European Union member states and organizations based in them will need to nominate a UK representative if they continue to trade or offer products and services or monitor public behavior within the UK after the 1st of January. And a key nub of today's presentation, any European data transfers, that is, transfers of personal data from EU member states into the UK, must adopt appropriate safeguards regarding the security and safety and integrity of that data. As a quick recap and reminder on the key elements of the legislation that come into account as a result of the Brexit decision, obviously Article 3 and the territorial scope of the GDPR is of paramount importance. Equally, the territorial scope of the UK GDPR will mirror exactly the obligations and provisions of the GDPR. And on that basis, the fact that the UK continues to adhere to the GDPR will mean that organizations trading into the UK will need a lot of the same measures, protections and safeguards as if they were dealing with any other of the European member states. Again, we'll look at that in some more detail a little bit later in the presentation. There are specific provisions within the GDPR that make reference to the challenge of overseas data transfers, whether those transfers are occurring from an EU member state into a third country or from a third country or other jurisdiction back into European member states. Articles 13 and 14 require an organization, be it a data controller or a data processor, to provide clear and transparent explanation to its clients and data subjects where such overseas transfers are taking place. Under Article 15, there's an obligation to inform and disclose, perhaps in response to a subject access request, to inform the data subject or requester where overseas transfers of their personal data are occurring. And this would apply to transfers to any jurisdiction outside of the European Economic Area, not just to the UK. But obviously the focus today will be on transfers into and out of the UK itself. Article 28 sets particular expectations around transfers and controls that are in place to protect the security, particularly where the data is being transferred either by or to a data processor, a third-party service provider operating under the instructions of the data controller. And we're all familiar at this stage with the challenges of having an appropriate contract in place mandated by Article 28 to ensure that the appropriate contractual clauses are in place for any such data transfers. Equally, Article 30 mandates that organizations with an obligation to complete a register of processing activities, and this usually encompasses organizations with more than 250 staff, or organizations which systematically and to a large scale process special category or sensitive personal data, then to the extent that they have an obligation to complete a register of processing activities, or ROPA, those organizations must mention within the ROPA registration the fact and details in relation to any overseas transfers of data which they process or which they oversee. Articles 44 and 45 of the GDPR contain specific considerations around safeguards that need to accompany the personal data in order for the transfer overseas to be lawful. And we look at some detail of those safeguards in a couple of slides. Also, it should be recognized that Brexit or no Brexit, the derogations provided to permit transfers of data, even without certain safeguards, are still in effect under Article 49. And as mentioned, these will continue to apply not only to European member states trading with the UK, but will apply to UK firms continuing to trade with the European Union and elsewhere. There are provisions under Article 58 of the GDPR which would permit a supervisory authority in certain circumstances to fully suspend trade or trade in personal data or the transfer of personal data between certain jurisdictions. To my knowledge, this has been very rarely invoked by supervisory authorities other than in the form of a threat should organizations not comply with instructions or with formal notices from the respective supervisory authority. But nonetheless, it's important to remember that the respective supervisory authorities around the European Economic Area will retain this right and will have those powers available to them. And lastly, while nobody wants to talk about the specific fines and penalties under Article 83 of the GDPR, it is worth noticing that those of you familiar with Article 83 know that the fines and penalties are split into two categories. One, penalized to a lower level of 2% of global annual turnover, or 10 million euro maximum. And the second category, Category B, against which a higher penalty cap is levied, namely 4% of global annual turnover, or 20 million euro, whichever of the two is the greater. It should be noted at this point that infractions and breaches of the regulation in relation to overseas transfers belong in the second category, the more arduous category of personal data breaches and fines and penalties. I'm sure I don't need to remind you today of the individual principles, and many of you will already have these tattooed somewhere about your person, so kudos to you for that. Other than just to remind you that all 7 of the principles of the GDPR, as well as what we often refer to as the 8th principle, namely the respect for individual rights and freedoms, are enshrined not only in the remaining GDPR, but in the slightly revamped UK version of the same regulation. So from the 1st of January onwards, in terms of the framework against which compliance with privacy legislation is determined, the 7 principles of the GDPR will continue, as will the individual rights and freedoms of the data subject. So from that point of view, no change there. Equally, the characters under the legislation will be essentially the same under the UK and European GDPR from the 1st of January onwards. It does behoove all of our organizations, however, to review their status, and we'll talk about this in a little bit more detail once I've explained. But of critical importance, organizations should review their particular status and the status of the partners or clients with whom they share or exchange or to whom they transfer personal data. Because the status of the controller and the processor, as well as the joint controller, become of critical focus under the new regime and from the 1st of January onwards. The terminology of the data exporter and importer, as we'll have seen in the past week, are of particular centrality to the standard contractual clauses, or SCCs. And for reasons I'll mention, the standard contractual clause will now come into focus as the critical and possibly most accessible mechanism by which personal data can be transferred to other jurisdictions, and in particular between the European Union, the remaining 27 member states and the UK from the 1st of January onwards. We look in a little bit detail at the status of the standard contractual clauses, not least because in the last few days, a long-awaited upgrade to the terminology and to the structure of the standard clauses has been published by the European Data Protection Board and the EU Commission. Not yet formally finalised and not yet complete, but nonetheless a strong indicator of the mind of the legislators in terms of the structure and provisions of those contractual clauses. We've already mentioned the nominated representative. In effect, the individual organisation nominated by a non-European organisation which is striving to do trade or to process the personal data of European resident citizens. Inversely, where European or other organisations are seeking to trade with the UK from the 1st of January onwards, they will need to nominate a legal entity to be their UK representative within that jurisdiction. Again, we'll look into this in a little bit of detail in a few moments. And the role of the supervisory authority has not gone away. So each member state, as well as the UK in its adoption of the UK GDPR, have committed to appointing and supporting an independent supervisory authority with primary responsibility for the interpretation and enforcement of the regulation in their respective jurisdictions. In that context, the Information Commissioner's Office, or ICO, in the UK remains the go-to or de facto supervisory authority for that jurisdiction. So from that point of view, no change. There are some implications, however, that we will look at in a moment. In terms of transfers to third countries, the European Union and the European Economic Area member states effectively recognise three expanding circles of countries around the world in the context of overseas transfers of data. In the first instance, the least friction occurs where data, personal information, is moved between organizations that are affiliated member states of the remaining 30 European Economic Area. That is, the remaining 27 member states of the European Union. I won't list them here today. And Norway, Iceland, and Liechtenstein, the three accession states who have joined to create the European Economic Area. This then is the most frictionless federation of countries through which personal data can be moved, because the data, by virtue of membership, can move across those borders safely and freely without friction, without need for additional safeguards. In addition, over the years, 12 countries have applied to the European Commission for consideration of the adequacy of the measures that they have in place in terms of rule of law, protection of individual rights, stability of government, and access to enforceable protections for individual privacy. Again, I'm not going to list the 12 countries just now. We'll come to that in a while. But safe to say that this creates an additional federation of countries around the world to which personal data can be shared by European member states without the friction of other safeguards. And essentially then, the rest of the world constitutes the third countries. Countries that are not European member states, are not members of the European Economic Area, and are not designated safe or adequate countries in the list of 12. For data transfers to any of these other third countries, the European Commission requires that European-based organizations adopt appropriate safeguards and mechanisms by which to protect the privacy, the integrity, and the autonomy of the personal data as it is being moved to and remains hosted in or resident in those other jurisdictions. Now, the Constitution, the criteria for adequacy are quite robust. It can be anything up to an 18-month to a 2-year assessment or due diligence audit process, and can be quite expensive. So although there is a backlog of countries who have applied to the European Commission for consideration of adequacy, the UK to date is not one of them. A quirk of the European legislation requires that European member states cannot, while they are members, apply for consideration of adequacy. Therefore, the earliest on which the UK can actually apply will be the 1st of January 2021. And based on experience with recent grantees of the adequacy status, namely Israel and Japan, the process of being audited for that benefit can take anything between 18 months and 3 years. So the designation of the UK as an adequate state is unlikely to be fast-tracked and unlikely to take place before 2024. If we assume a no-deal Brexit, then it's likely that we will also need to consider future scenarios as time evolves after the 1st of January 2021. Naturally, there's every expectation that the UK will continue to do business, offer goods and services, and process personal data with European member states. That those data flows will continue on the basis of what will be considered appropriate safeguards from the 1st of January onwards. But equally, there's every expectation that over time, the UK version of the GDPR and its associated privacy legislation are likely to diverge more and more from the European version of the same regulation. Equally, that the ICO's interpretation and enforcement of that legislation is likely to vary strongly from the European consistency mechanism that would keep that consistency across the remaining member states. Therefore, over time, there is every expectation that the UK version of the GDPR and its interpretation and enforcement will diverge and vary from the broader European version. This isn't news, and if those of you who remember world before the GDPR will recognize that back in the noughties or the early teens of this century, that was the reality, in that even among the European member states, there was substantial divergence and disharmony in terms of how privacy legislation was being interpreted and enforced. So if anything, the 1st of January will introduce the start of a similar regime and a similar reality in the coming years. Equally, given that they have no mandate or obligation to do so, there's every likelihood that from January onwards into the following years, the UK will cease to adopt changes to the European legislation or any amendments that might be made to privacy or similar legislation in the coming years, meaning that there will be a two-tier, or at the very least, a staggered response to European legislation in the UK. So again, that divergence or differentiation is only likely to become more deep-seated over time. And equally as well, as a natural consequence of the Brexit decision, guidance from the European Data Protection Board and from the European Court of Justice will no longer have effect within the UK. The UK may adopt or may recognise the value of some decisions and of guidance from the European Data Protection Board, but will no longer be mandated to adopt those guidances or those advices. Just by way of reference, the safe countries, you have them there. And to mention as well that both South Korea and Turkey are about to join the happy family of the safe countries or adequate jurisdictions that have formally requested an evaluation of their privacy and data processing activities in order to get that safe designation. In the interim, the organizations listed will no longer have to be concerned, but are also recognized by the UK for their safe designation. From the 1st of January onwards, organizations as currently will need to determine whether they have an obligation to continue to comply with European legislation. The criteria for UK companies continuing to comply with European law will be where they continue or start to offer goods and services to European-based clients, where they process the personal data of EU residents, that is, any individual resident in an EU member state, whether they are European citizens or not. Naturally, if a UK-based organisation employs European citizens, they will be obliged to abide by the provisions and protections of those citizens as set out in European law. And equally, where a UK-based organisation monitors the behaviour of individuals resident in the European Union, they will be obliged to abide by the provisions of the European legislation, not just the GDPR, but legislation in relation to employment, social welfare, personal integrity, intellectual property, etc. I mentioned earlier on the obligation to appoint an EU or UK representative. This is with reference to Article 27 of the GDPR and will apply only to organisations who do not meet the following criteria. Where the organisation, be it a controller or a processor, is a public body or public authority, they are exempt from the obligation to nominate, respectively, a European or UK representative. Equally, where the processing of personal data that they conduct is occasional, where it does not include special categories of data or criminal convictions and criminal offences, and where the processing is of such a nature that it is unlikely to result in risk to the rights and freedoms of individuals, then there will be no requirement to nominate a UK or European representative, as the case may be. However, even though organisations might enjoy that exemption, they will still be obliged to abide by the provisions of the European or UK GDPR and the associated privacy legislation relevant to their respective jurisdictions. So under the context of what happens next, I've taken the liberty of splitting this out from three perspectives: that of companies based in the UK, that of companies based in Ireland and the remaining EU member states, and then the perspective of organisations from elsewhere in the world seeking to trade either or both with the European Union and with the UK. Again, a copy of these slides will be available, so apologies if the text is quite dense, but I will try and go through them at high level, and a copy will be made available to all attendees registered for today's event. From the perspective of UK companies, they will continue to abide by the GDPR, albeit switching to the modified UK GDPR and the amended Data Protection Act 2018. The ICO will remain the supervisory authority as currently, but will no longer be able to be the lead supervisory authority for investigations or the management of complaints that would involve the participation of other European member states. Naturally, there's every hope and expectation that the UK will continue to trade with its European member states, including facilitated flows of personal data. The UK continues to recognise the status of the 12 safe countries, which I've just outlined. And this has been reciprocated, it should be said, by 11 of the 12 safe countries. To date, as we speak today, Andorra has not yet agreed to abide by the designation of the UK as a safe jurisdiction. Nonetheless, the other 11 member states of the safe family have recognised their intention to continue trading with the UK on the current basis. The UK will continue also to abide by the recent decision in relation to Schrems II, namely the adoption of appropriate safeguards when transferring personal data out of the UK to a third country or other destination. So those provisions enshrined in the GDPR will continue to be adopted by the UK, given that they recognise the CJEU decision that came through in July of this year, namely the disbandment of the Privacy Shield mechanism and the introduction of other appropriate safeguards. We'll talk in a few moments about preparation for the deployment of the revised standard contractual clauses. It should be said, however, that the draft clauses that have been issued for review are not yet taking effect, and it's likely to be early in the new year before the formal modular clauses are introduced. UK companies that meet the criteria just outlined will also need to prepare a nominated representative based in and established in at least one EU member state. The member state that they pick for their nominated representative should be a member state in which they conduct a substantial proportion of the processing of personal data. The representative must be a legal entity, and the obligation on the UK organisation to notify the relevant supervisory authority in that jurisdiction of the fact that they have nominated a representative there. They should also modify any privacy notices or websites to make reference to the fact that a UK representative has been nominated and selected. We encourage UK-based organisations to review the contractual arrangements they have with their European clients, and to expect that their European clients will reciprocate, as we'll see in a moment, by reviewing the contractual terms that they have with their UK-based controllers and processors. UK companies employing both European and UK citizens must realise that they will need to comply both with UK and European regulations. This is particularly true in Northern Ireland, where there's many employees from both sides of the border working respectively in the other jurisdiction and employed by entities based in those jurisdictions. And therefore, the weight of both pieces of legislation across all the pre-mentioned categories, such as employment, social welfare, health, entitlements, etc. The regulations in both jurisdictions will continue to apply. Of particular importance is that any UK companies which had nominated the UK as their main establishment when continuing to process data across the European Union will cease to exist. The UK can no longer be nominated as a main establishment for organisations. This is less of the case for the UK companies and much more of an issue and implications for non-EU or non-UK companies. And lastly, as mentioned, certain legislation continues to apply, such as the Electronic Communications Regulation, Freedom of Information, NIS, and IDAS. They will all continue to apply, albeit with some modifications in light of Brexit. You'll see remarkable similarities here from the other side of the fence. Irish and European organisations will have to adhere to a number of modifications, again triggered by the Brexit decision. Obviously, they will continue to abide by the GDPR, continue to recognise the safe countries and the provisions of the Schrems decision. They will also need to review all data flows that are being sent to UK controllers or processors. They will need to modify and prepare to include appropriate clauses or mandates into those existing contracts no later than the end of 2021. There will be a degree of latitude for pre-existing contracts once the new standard clauses templates have been adopted and published. Again, for Irish and European companies seeking to trade and do business with the UK, a UK representative must be nominated to match the obligation of having a European representative for UK companies. Again, it must be a legal entity, must be established within the UK, and the Irish or European companies must notify the ICO that they have nominated an individual organisation. Equally, as with the UK companies, they must modify any privacy notices or statements to recognise and reference the details of the nominated UK representative. Of particular importance will be the obligation for Irish and EU companies to review any contractual arrangement that they may currently have in place, either with clients, service providers, or subcontractors within the UK, because, as mentioned, those contractual terms are likely to change substantially from the 1st of January onwards, particularly in the context of a no-deal Brexit. Any non-UK company which had established or identified the UK as its main establishment, particularly where Irish or European companies were trading in multiple European jurisdictions, and this would be true in particular in the financial services sector, many organisations of whom had nominated London as their main establishment, given that up until now it has been a centre of financial trade and practice. That main establishment designation can no longer apply to the UK from the 1st of January onwards. So organisations who had made that nomination will need to rethink their main establishment decision and nominate an alternative European member state as their main establishment. And as before, there will be a continuity of abidance by the various electronic communications, freedom of information, particularly of value in Ireland, the health research regulation around clinical trials and pharmaceutical trials, etc. So those laws, to use a phrase, have not gone away and will continue to apply. And lastly then, from the perspective of companies elsewhere in the world, outside of the UK and the European Union, these organizations may have the biggest challenge, because if they continue to trade both with the European Union and with the UK, then both versions of the GDPR will apply to them, and they will need to be very clear on the respective circumstances under which either the European or UK versions of the regulation will apply. They will also need to look at all data flows between themselves and UK-based controllers and processors, as well as prepare for the adoption of standard contractual clauses, which are likely to be coming at them from their European-based or UK-based clients, service providers, and subcontractors. So again, those are the main changes from the three different perspectives that we will anticipate, particularly in light of a no-deal Brexit. I mentioned earlier the obligation to have appropriate safeguards in place, and in particular, Article 46 of the GDPR sets out the expectations by which European and UK organisations will need to ensure the safety, the integrity, and the protection of personal data that leaves their borders and is transferred to another jurisdiction. Whether those mechanisms are covered by an approved certification as defined under Article 42, or the binding corporate rules mechanism, which is outlined in Article 47. As mentioned previously, relatively few companies around the world are big enough or complex enough to adopt or consider binding corporate rules as their appropriate mechanism for safeguarding data transfers. It should be noted as well that binding corporate rules only apply to the intra-company transfers, so transfers of company between subsidiaries of the same organization, which might be dispersed around the world. Again, quite a convoluted and expensive process, which might explain why relatively few organizations have taken that measure. Article 93 of the GDPR specifies the provision of standard contractual clauses as one mechanism by which personal data can be protected when transferred outside of the jurisdiction. And as we'll see in a moment, the additional focus and renewed focus just recently, not least in the last 5 days, by the European Data Protection Board to revamp and upgrade the content of the standard contractual clauses has been triggered not least by the immediacy of the Brexit decision. There's also a provision under Article 93 of the GDPR to allow for a supervisory authority to adopt separate extraordinary clauses which might be acceptable to that supervisory authority in the protection of personal data in certain circumstances. Alternatively, aside from these mandated mechanisms outlined in the GDPR, organizations are obviously free to address and define contractual clauses between them. But at the very least, those mandated or edited clauses must at the very least meet the obligations, the minimum obligations of the standard contractual clauses as outlined by the European Data Protection Board and the European Commission. Lastly, to mention that with all this talk about friction-free movement of personal data, Article 49 has continued to offer derogations or exemptions under the regulation for certain processing of personal data. There is no requirement to adopt advanced or additional safeguards or to determine the adequacy of the destination in these circumstances. For example, where the data subject has given explicit consent, where the transfer is necessary for the performance of a contract, or for the conclusion or management or negotiation of a contract, where the transfer is necessary for processes of public interest, human interest, or the protection of the vital interest of data subjects. So with all the discussion of safeguards and other mechanisms, it should not be forgotten that Article 49 continues to permit certain transfers of data outside of the jurisdiction, as long as those circumstances apply. Where an organization is adopting those mechanisms or availing of the Article 49 derogations, they must be referenced in the Register of Processing Activities, or ROPA, which has been drafted and defined by the organization. And equally, with references to Article 13 and 14, the transparency obligations, the organization must notify the respective supervisory authority and the data subjects whose personal data may be impacted by such transfers. We've talked a bit at this stage about the standard contractual clauses. The standard clauses are set out as one of the mechanisms under Article 46, which would permit the transfer of data between jurisdictions. Until a couple of days ago, the standard clauses template available to European member states effectively derived from the 1995 directive and was drafted in 2004. Thankfully, with all the focus on the Schrems decision and on the impending Brexit date, the good people in Brussels have drafted a revised format for the standard clauses to reflect 4 separate scenarios. The 4 scenarios are listed here, where the data transfer involves a European controller transferring to a non-European controller, a European controller transferring to a non-European processor, 2 processors, one within and one outside of the European Union, transferring data between them, or an often neglected scenario, a non-European data controller processing data or providing instructions to a European-based processor to process data on their behalf. As mentioned, these revised modules have been circulated by the European Commission for review, and we are likely to get modifications and final versions as early as January or February of next year. Nonetheless, while those contracts are still being negotiated, the existing supervisory authorities will accept the existing standard contractual clauses. And we have indications that a 12-month sunset period will be adopted, which means that any standard clauses currently in place will be allowed to continue as effective for a 12-month period or until those contracts come up for renewal, whichever occurs the sooner. So there is a degree of latitude before organizations need to deploy the revised standard clauses templates from the 1st of January onwards. But again, as I say, this is very topical and very new. So please watch this space, and we will be providing additional advice and additional information through Cytorus once we get the clarification from the European Commission in relation to those modified templates. I don't want to paint an unnecessarily bleak picture of the future. There is every opportunity, fingers crossed, that a deal may yet be struck, or at the very least that an interim trade agreement may be arranged that would allow for the free movement of data, even while broader trade and legislative negotiations continue. There is every likelihood that these negotiations will continue right down to the wire to the end of December. And a summit on the 28th of December has already been mooted as a possible date to allow for the very last possibility of a trade agreement to be put on the table and accepted. But bear in mind that any draft agreement must be acceptable universally to all remaining member states of the European Union, that is the 27 remaining member states. So the challenges only increase as the clock ticks down towards year end. Obviously, we anticipate further guidance from the European Data Protection Board, not least in relation to the safeguards, but also in relation to the revised templates of the standard clauses. And there's every possibility, again, fingers crossed, that despite history and despite the challenges and queue jumping, which we know that the UK hates, there's every possibility, given the volumes of data involved, that a decision regarding UK adequacy may well be fast-tracked by start of the new year. So some immediate considerations for organisations that we can only encourage as we approach year end and the Brexit date. Obviously, regardless of whether you're based in the UK, the European Union, or it's specifically here in Ireland or elsewhere in the world, we strongly recommend that organisations review their existing data flows and transfers, and in particular, review the contractual arrangements with the partner organisations, the recipient, or as the case may be, the exporter of the personal data to your jurisdiction. And in particular, to understand the characterization of your organisation, your role in that processing. Are you a controller, a processor, collaborating as a joint controller, maybe subcontracted as a sub-processor, and particularly, are you exporting data outside of your jurisdiction or importing it into the jurisdiction from outside? In time, organizations will need to consider the appropriate of the 4 standard clauses modules to best suit their characterization of the data flows that they are conducting. And equally, to adopt additional safeguards, not least as a result of the recent Schrems decision by the by the European Court of Justice. We ask you as well to review and consider the detail of your privacy notices and policy documents to ensure that they are an accurate reflection of your data transfer applications and processes, so that data subjects are fully clear in terms of how their personal data will be processed by you. We ask you to consider your register of processing activities, bearing in mind that under Article 7 or Principle 7 of the GDPR, in terms of your accountability and responsibilities, you must proactively ensure that your ROPA or Register of Processing Activities is an accurate reflection of your processing activities. And also consider the candidates where necessary if you need to appoint either a UK representative or an EU representative. Bear in mind the criteria already outlined, which we'll recap on review of these slides. But this must be a legal entity established in the jurisdiction in which you are nominating them, and they will represent your interests, including being investigated and possibly even being prosecuted. Therefore, the organization you nominate must have the appropriate skills and knowledge to deal with GDPR-related matters on your behalf in the jurisdiction in which you nominate them. So again, that is not a casual decision. And if you haven't already given some thought to it, we can only encourage organizations to start doing so immediately. For our part, within Cytorus, we have adopted a Brexit impact assessment, which is a turn on the Data Protection Impact Assessment, or DPIA, built into the GDPR, but with specific focus, as the name suggests, on organizations that are impacted by the Brexit decision, whether UK-based, European-based, or anywhere else in the world seeking to trade into the UK or the European Union. The product includes an assessment and evaluation of current data flows, an evaluation of third-party processes and the destinations or third countries to which the data is being processed, as well as assisting organizations in identifying the appropriate adoption of contractual clauses, an upgrade of their register of processing activities, and an outline or enhancement of the risk register of the organization. We're more than happy to field any questions you might have in relation to that particular service. Before I finish, and I'm not conscious that a number of questions have come up, so I will look at those now in a moment. But in the context of this ongoing series of presentations, I'm delighted to draw your attention to the fact that a further webinar is scheduled for 3 o'clock, 1500 hours on December the 10th to focus on managing risks for privacy teams. So again, check out our website at www.cytorus.com to register for that event. Thank you very much for your attention and for your stamina. I know today was a whistle-stop tour of the GDPR implications, but I hope the outline has made sense, and I will certainly try now to address any questions that you might have. In the sequence in which the questions were raised, and bear with me as I try to get through as many of these as possible. I will, however, in deference to yourselves and your stamina, call a line at 10 past the hour, because and we'll follow up then with the individual registered attendees with answers to any questions I don't quite manage to get to. Sean raised a question, sorry, an anonymous attendee, I'm not sure I should be reading these out, does ask, does the nominated representative apply to processors? If you as an organization are processing personal data within these respective jurisdictions, either in a capacity as a controller or in your capacity as a processor, you will have an obligation to have a nominated entity representing your interests. That means particularly if you are not ordinarily established in the jurisdiction, you need to have an organization offering those services and representing your interests in that jurisdiction. So in short answer, to my knowledge, the obligation to have both a nominated representative and a UK representative, respectively, will apply to processors as well as controllers. Sean asks, if we have employees in both Northern Ireland and the Republic, what consideration for personal data transfers applies? As mentioned, Sean, where you may be a UK or Irish organisation employing individuals both sides of the border, you will have an obligation to adhere to the obligations of both sets of GDPR, both the European GDPR, the mother legislation, and the UK version of the same legislation, as well naturally as considering the employment and welfare and social entitlements of those staff, of those employees. So where that applies, organizations will need to adhere to the obligations on both sides. As a subset to your question, Sean, you ask about third-party payroll services. So again, that will be effectively a data processor based in the UK, sorry, based in the Republic of Ireland, going by your question, providing a service to employees in Northern Ireland. And therefore, the data transfers necessitated by that third-party arrangement will be spelt out in the standard clauses. Just looking at some of the remaining questions, some of you had to leave, and that's unfortunate, but as I say, the slide deck and the recording will be available if you can stand the excitement of having to listen to the whole thing again. There's a question from Ramona, was Privacy Shield not deemed inadequate by the DPCO? Yes, indeed. And sorry if I gave any impression that Privacy Shield still has any merit. I'll certainly review my recording, but Privacy Shield was decommissioned with immediate effect back in July of this year, following a decision by the European Court of Justice. It's important to mention that both the UK and the remaining member states of the European Union have all adopted that decision. So the UK will not consider Privacy Shield to still be live from the 1st of January onwards. There's no question of a reversal of that decision by the European Court of Justice. So again, apologies if I give any alternative understanding, but Privacy Shield has been removed as a possible safeguard for the transfer of data either from the European Union or from the UK to the United States. And as such, alternative safeguards and alternative contractual arrangements will need to be adopted. In terms of further questions, please bear with me. Is there a resource where we can view the new draft standard contractual clauses templates? Yes, hi John, there is indeed. We have the template available. We'll make it available through our own website, and it is available on the website of the European Commission and, to my knowledge, the European Data Protection Board. As well as that, several legal firms in the past couple of weeks have made very useful observations and very useful communications in relation to the draft modules and the draft content. But as I say, if you bear with us, by close of play today, we'll be able to load up the draft templates onto the Cytorus website and make them available for you to view. In relation to the new standard clauses, does the third scenario include European data processor to non-European sub-processor? It includes both, again, the anonymous attendee. The question is whether the third modular scenario relates to data processor to processor or data processor to non-European sub-processor. Naturally, in the typical life cycle of a data engagement, a European processor, if they nominate a subcontractor for an element of that work, is effectively identifying a sub-processor. Where that non-European or where that sub-processor is based outside of the European Union, then naturally the third module of the revised standard clauses will apply. There's a question in relation to the status of the nominated representative and whether or not they can be an individual. To our knowledge, the nominated representative must be a legal entity. Now that can clearly be a self-employed individual. For example, a business person, a contractor, a solicitor, as long as they have the appropriate indemnity and insurance cover, as well as the appropriate knowledge of the role and of the regulation. Bear in mind that the nominated representative, or as the case may be, the UK representative, is not merely a postbox or a point of contact to take calls like an administrator or a shared services office to take calls on behalf of the nominating sponsor or data controller. The nominated and UK representatives will become the prosecutable entity for the data controller in that jurisdiction. Once nominated, that entity will be contacted by the Commission or the supervisory authority in the case of a complaint or of an investigation. And all correspondence, as well as all prosecutions, will be aimed and targeted at either the nominated representative or the UK representative. They then in turn will pass on those obligations, compensation or prosecution and penalties to their respective nominator. So this is not a casual or a lightly considered decision. Organizations need to make sure that they pick a nominated or UK representative that can professionally and adequately represent their interests in the jurisdiction in which they are nominated. There's a question from Nadia whether a sub-office in Northern Ireland can be automatically the UK representative. That's fine, as long as it's a legal entity established in that jurisdiction, they can certainly be your UK representative. But the nomination of a UK representative is more for organizations who are not established within the jurisdiction. For example, a non-European, or as the case may be, non-UK entity seeking to do business in those respective jurisdictions. If you already have a sub-office or an established entity or subsidiary in one or other of the jurisdictions, then effectively they are the UK representative, or as the case may be, the European representative if they're based in one of the remaining European member states. Will Privacy Engine be updated to reflect the UK Data Protection Act and GDPR, where there are variations? Yes, indeed. The anonymous attendee has been very busy today, but also very pointed and very valid questions. Privacy Engine, once we know what the relevant changes will be, albeit minimal, to the UK Data Protection Act and to the GDPR, appropriate changes will be introduced to Privacy Engine. For those of you who may not know, Privacy Engine is the Data Protection Officer portal designed and built and hosted by Cytorus, and is available for review and for a dry run, or at the very least a demonstration. Simply get in touch with the office and we'd be more than happy to take you through the functionality. But in short answer to that question, we're more than happy to confirm that the appropriate modifications will be made to Privacy Engine once the appropriate changes have been published on the respective pieces of legislation. There's a question in relation to the applicability of employment law where a UK business employs European citizens. That is, and I should have been clear, apologies if I was unclear in it. If a UK business employs European citizens resident in a European member state, then obviously European legislation, including the GDPR and the respective privacy as well as employment legislation for that jurisdiction will apply. If it's a UK business employing European citizens in the UK or within Northern Ireland, then obviously UK legislation will apply. Hopefully that's more clear, and apologies for any confusion I may have caused. There's a question again by our old friend, the anonymous attendee. How prepared are UK companies for this? I'll be honest, from recent readings, fewer than 25% of UK companies, to my knowledge, have actively prepared for the GDPR or for Brexit on the 1st of January. Every indication is that a combination of being distracted with COVID-19 plus a faint hope that negotiations will win out and that a deal will be done by the 31st of December have meant that many organizations have not taken up any kind of initiative to focus on their GDPR or their privacy data transfers. Interestingly, from my colleagues and peers in other industries, I am aware, for example, that in the fast-moving consumer goods, in the farming sector, logistics and transport, hospitality, many of these sectors and industries have taken a far more active interest in ensuring that they are Brexit compliant and have taken account of the various modifications needed. This hasn't been helped by the fact that there is a dearth of information available, accessible information for companies struggling to prepare or to understand the implications of Brexit for their respective business. And as recently as last week, complaints were being raised, not least by the UK and the European transport authorities, complaining as to the lack of accessible information, and in particular, the lack of information in the appropriate languages for drivers and transport haulage companies to anticipate and prepare the appropriate materials, the appropriate certifications and documentation that would be needed. An interesting statistic was that 80% of the drivers transporting goods into and out of the UK are not English speakers. And therefore, where any of the guidance is only available in English, there's going to be a natural delay before those organizations fully understand the implications of the GDPR and of Brexit in that context. Elaine has mentioned that she's already registered with the ICO as a data protection officer for a UK registered company. And one assumes, will it be sufficient to nominate the UK entity as our EU representative? No. In answer to your question, Elaine, You've asked, will it be sufficient to nominate your UK entity as the European representative? And in short order, no, it will not. You must nominate an entity established in one of the remaining 27 European member states. If your UK company is only trading in the UK, then you have nothing to worry about. But if your UK employer is engaged in other member states of the remaining 27 countries, then you will have to nominate a European representative in at least one of those jurisdictions. They must be a legal entity and must be established in that jurisdiction. So your UK entity cannot be your European representative. And vice versa, for a European-based company, their UK or their European subsidiary in Berlin, Frankfurt, Madrid, or Dublin cannot be, for obvious reasons, their UK representative. It must be an entity established in that jurisdiction. I'm aware that there may be one or two more questions. Just bear with me, please. Shampa has raised a question. An Irish company processing data of UK customers in Ireland, but with IT infrastructure and servers located in the UK. So you're an Irish entity, but relying on the services and probably transferring personal data over and back to your service providers, namely your data processors in the UK. On that basis then, I strongly advise you to look at the modules of the standard contractual clauses that will apply, given that the European GDPR will apply, given that you're established in Ireland, but also that the standard contractual clauses will apply to the transfer of personal data. And specifically based on the revised modules issued last week, module 2 is the one that will apply, i.e. the transfers of personal data by a European-based controller to a non-European data processor. That scenario is reflected in module 2 of the revised standard contractual clauses. Folks, I know I've gone over time. I'm mindful of your patience and attendance, but also that life is short and there's only so many hours we can spend going through this. I'm mindful as well that a couple of other questions have been flagged. I'll take every opportunity to address those back to the questioner in due course, and very much appreciate your attention and your participation in this afternoon's presentation. I hope it's helpful, and as I say, the slide deck will be made available to you if you are a registered attendee at today's session. And please don't hesitate to get in touch with Cytorus at any stage if we can provide further advice or further support to you as you tackle the challenges of preparing for Brexit. Thank you very much again, and it's been a pleasure meeting with you this afternoon. Take care. Bye-bye.